The Ethical Humanist Society of the Triangle promotes the use of reason and science in the search for and commitment to living an ethical life that benefits all humanity. We believe that personal inquiry, responsibility, and accountability are the best bases for ethical decision-making. Our weekly forums seek to broaden our understanding of ethics and human nature, and our congregational community encourages us to share diverse opinions, friendship, and camaraderie. We welcome everyone to share in our journey. If you'd like more information about our community, please let me know following the platform. We also have a visitor sign-in sheet. I hope you signed in with Jennifer over there at the greeters table. And there's also some literature over there. So we hope you find that helpful. Because we're a community, let's take a moment to share any joys and concerns. Okay, Chris.
I wanted to give an update about Jane's sister, Kathy. Kathy is now out of intensive care in the neurological unit in Charlotte, but she's now in progressive care, which is still considered intensive care, but it's a sign that she's getting better. So she is better, but she has not made a full recovery, and we don't know what the prognosis is, but we're all happy that she's in a progressive unit now.
That's definitely a joy.
Well, the Science Book Club did a book called Conversations on Consciousness, where they talked about a lot of really interesting people, from Dan Dennett to Francis Crick, about what they think consciousness is. And it would be a great nonfiction book for our group. That's be the time after this one. And most of them did not believe in an afterlife, although some of them looked forward to downloading their brains to a computer so they could live on in the internet, which would be an interesting place to be.
Yeah, these are interesting times. AI. Yeah. Oh.
Hi, I'm glad to be back with everybody today. I know I've been absent beyond explanation. Hi. And the last time I was here was right after I had moved into Galloway Ridge, 6 weeks ago, or a little, I guess. So since then, I have been to Phoenix to my nephew's wedding, been to California to bury my parents' ashes, and my house. Yay. So that closing happened on Friday. So that's over. And I feel that soon I will be able to start my real life. A lot been going on. It's good to be back.
Hello. I have a concern. And between the years of 1905 and 1930, there's a period that we call industrialization. It brought us movies, cars, airplanes, radio, a revolution in our way of life. It also brought us mass communication, mass slaughter, mass production, mass poverty, and in slums. And these changes actually made freedom and happiness forever impossible. However, industrialization in the period is usually viewed as virtuous. And that's my concern. And this is brought to me by an author named Aldous Huxley. He's written several books, and many of them about this particular matter of how industrialization has robbed us of happiness and freedom in life. And it's kind of obscure, but also obscure is why we're having mass killings, mass shootings every day. You turn the news hour on, and who can explain that? There's something going on there, and it's not easy to know what it is, but this is a concern. I think that it's possible that this period of industrialization should not be viewed virtuously as a virtue. And so I wonder if anybody else is concerned about that.
I do think that it's slightly concerning, Gordon, I agree, but I have a joy and a concern. The joy is that the little group that I sing with was invited to go perform at Umstead Park this weekend on yesterday, because they were doing like a big race, bicycle running, all that stuff. The concern is just the same as 4 years ago when we went, it rained too much for us to go on the stage. We're considering calling ourselves the Rainmakers and maybe like go to Farmers. We haven't decided.
I have a, oh, you want to?
Well, I don't have Gordon's worry. Certainly in the 30s, they were worried. Before Orwell got some inspiration from the Industrial Society, a book saying we'd all end up being cogs in some giant machine like in Metropolis, but it hasn't happened. All those things you mentioned let us live freer, more exciting lives and give the individual more power to do things there.
Gordon is the most important development in those 25, 30 years. We got the vote and the development of quantum mechanics, which is the basis of a lot of things, physics, chemistry, biology. I know Dorothy would recoil in horror, but that is true. I have a concern. Christina is quite ill. He came back, returned from California on the March 28th, I think. Yeah, March 28th with the virus. And it has just has become worse, triggering asthma, causing infection in her throat and chest. And so she is still ill, quite ill and miserable. So she sends a regret. She was hoping she was feeling quite well yesterday, but then it went all south last evening. So when I left, she was still sleeping because she didn't get to bed like 7 in the morning or something like that. Anyone else?
Sorry to
To
hear
the
that.
joyous note?
Anyone from this side?
Oh, sorry.
I'll just share a quick joy. I am fresh back from Jamaica last week, so if I'm running a little bit on island time, I apologize. So, and of course, with time moving as fast as it always seems to be, my best friend who traveled with me, we were calling each other the day before saying, so who's picking up who from the airport? So let you know how fast we came into the vacation and how fast we got out. So, but glad to be back.
Going to Jamaica now being late. It has dissipated from your body. Anyone else? Sorry. Okay, go on.
I should recognize my own joy. My cat, who's 18 and a half, got out of the hospital after 2 days, and he has 4 new medicines, but he's alive and I'm thrilled. Okay, Amy, would you like to do opening words? Thank you.
Oh, rather than move this, sometimes, is it okay? Okay. I regularly go browse through the new bookshelves at the public library, and I found this thin volume called Keep Multiplying Like Rabbits, Volume 9. Woo! Well, that caught my eye. And the author, the poet Jack Tomkovic, is a retired social studies teacher and he lives in Chapel Hill. So I thought I would share a couple of his short poems with you. The first one is Selling Fear, and this was written in September of 2020. And that was the summer of Black Lives Matter protests. So it's called Selling
fear. Selling fear like breakfast cereal, Trump and toadies dash like dervishes, beer here at the ballpark and fear here on the campaign trail. Selling fear like pre-driven cars on late night TV with engine Joe Jones, tools that slice and dice, chop and mash, fortify and filigree, precision poetry in kitchens white as snow, soiled solely for the TV show. Selling fear plus an unhealthy dose of racism, kick women and death for young Black men targeted by race, dying as often as Russians fall out of windows in winter.
So welcome, everybody. Thanks for having us. We're excited to be here. My name's Phil Dixon. I am, my title is Defender Educator and Assistant Teaching Professor at this UNC School of Government. What that means is that I mostly train public defenders and people that do appointed public defense work representing the indigent in criminal cases. So I'm a criminal law expert. I have sort of a subspecialty in drugs. This is Sarah Olson. She is, I work at UNC School of Government, but my position is largely funded by IDS. That's Indigent Defense Services. That's our overseeing state agency that runs the public defense system in the state. Sarah's whole job, so we're both licensed lawyers in North Carolina, but I don't practice anymore. She doesn't practice anymore either. We both do a lot of consulting though, trying to help the public defenders and people in the defense system get their cases right, provide a vigorous defense in their case. I get all the questions on everything basically, but it's more like law and procedure that I'm typically advising on. Sarah is forensic resource counsel. So she's a lawyer, not a trained scientist, but she spent a career learning the science. And, when somebody calls me, and this happened Friday afternoon, somebody calls and says, I've got a DWI case. It's cannabis that's alleged to be the impairing substance. I've got this lab report from the SBI. It says, 1.5 nanograms per milliliter of blood of Delta 9. What does that mean? I said, call Sarah. That's how, and we work together that way. So I plan the trainings. Sarah is usually an integral part of that with forensics trainings for my attorneys. So most of this is going to be, I'm going to let her do a lot of the talking because it's really her area of expertise. But I figured I'd start and give you sort of an overview of the law. We're both real easy, like, please just speak up. If you got a question, I mean, if you want to raise your hand, that's fine. But if you just want to shout something out, we're happy to try and help. Yes, ma'am. Well, I'll let y'all figure that out. So thanks for having us. That's us. That's our roles. And I'm a little different at the School of Government in that we are politically and party wise neutral. But I do have a sort of unique role in that organization, and that I do advocate for defenders. So I'm trying to walk that tightrope of not necessarily advocating one view or another, but I do certainly have my own views about it that are influenced by the fact I've been a career defense lawyer and I work with defenders exclusively. If I seem a little jaded or flip, that's why. Our goal is just to basically give y'all an overview of what we see are like common issues and stuff that we deal with in these criminal cases as far as forensic evidence goes. I am just going to give you a quick, broad sort of view and then turn it over to her, and I'll try and chime in as needed. I want to start with sort of the relevant legal rule. Lawyers and judges and any court case is guided by the rules of evidence. That's just like I'm sure you've heard of it, but it's a whole code of rules about what can and can't come in at criminal trials or any trial. how, the necessary prerequisites for the admission of certain testimony, limits on things that, can or can't be admitted. And we've got one that speaks, basically to this stuff, which is Rule 702. It's about expert testimony. If we're talking about forensics, there's going to be an expert presenting that, and they're going to give an opinion, and they've got to do so in accordance with Rule 702. And that's the same in the federal system. That's the same in most states. Most people, if you hear someone saying Rule 702, they're talking about expert testimony. And it sounds really good. Like the rule says that you have to have sufficient facts and data, that somebody with a sufficiently reliable method or principle, and that data and the methods have been reliably applied in the case. So if that was done in all the cases, we wouldn't have forensics issues, really. What's the problem? Anyone?
Everybody's definition. That varies.
Not only that, right, but we're all trained lawyers and judges. We're not scientists. So the judge has this role to be the gatekeeper of the forensic evidence, and he's supposed to evaluate, was this based on sufficient data? Are these reliable methods? And did this expert in particular reliably apply those methods to the facts of this case? But that's a guy that went to law school. He doesn't have, almost without fail, we don't have any rigorous scientific training or background. We depend on the experts largely. So that's sort of a, out the gate problem. I mean, patent lawyers maybe have some scientific training, but not many of us in the criminal system do. That's why someone like Sarah exists. And I just back up and say, we're very grateful to be in the positions that we're in. There's not a lot of jobs like ours anywhere. And a lot of states don't have people like us that help advise court system actors. So, we're not scientists. And there's all kinds of gaps in how that Rule 702 gets applied. I'll give you one example right out the gate. It's actually written into our state rule that says, if the officer has taken the class and gotten a certification, I think it's like a 4 or 8 hour class that they have to take to get the certificate, then they can do an HGN test on somebody, and those results are admissible. Does anybody know what HGN is? It's an acronym for horizontal gaze nystagmus. Does that help any? All right. There you go. Yeah. So you've seen this if you've ever watched a DWI arrest or interaction or even investigation, but the officer shines the light in their face and says, follow my finger. I want to put it over here, put it over here. And they're looking for small twitches in the eyeballs. State troopers and law enforcement are also not trained scientists or experts typically, although they do get some sort of certification to perform this test. Now this is, my example. That stuff, that test, the HGM test, there's obviously like really specific ways it's supposed to be done, 6 inches from the nose, hold it at sustained angle, 90-degree angle for 4 to 6 seconds. There's like these specific instructions. And there's been a lot of study of that kind of test, and we've determined it's about 77% accurate at determining whether someone's impaired when it's done under perfect circumstances, under a controlled setting. When is this test usually done? On the side of the road as traffic goes by with lights flashing in their face, right? It's not a controlled setting. And really, before the advent of body cam and dash cam, it's just whatever the officer says it is. I noticed 6 out of 6 cues of impairment. Therefore, it's my opinion he's impaired. That's how it goes. And even now with dash cams and body cams, they take them off camera to do that test so that it's not recorded. So that's a little example of forensics, but that's a common one that comes up in district court cases every single day. And just forgive me if I'm using lingo. If I need to clarify my jargon, let me know. But we try misdemeanors in district court, and you don't get a jury there. You go in front of a judge. If you don't like the result there, you can appeal and have a jury trial in Superior Court, and felonies go to start and finish in Superior Court with a jury. But this kind of evidence, that kind of opinion from an officer who gets up and says, I've taken the class, I'm certified, I know how to do the test, I did the test correctly here, and it's my opinion this person's impaired, that's going to carry a lot of weight with most judges, and it carries a lot of weight with most juries. But how reliable that really is on the ground is debatable, I'd say. And this, what's true for that would also, to stick with DWI for a second, also applies to the other field sobriety tests. Those are actually less reliable than HGN. HGN is considered the gold standard, but the walk and turn test, I want you to go 9 steps down the line, 1 foot after another, do a specific kind of turn, finger to nose. There's all kinds, 1 leg stand. And whether that stuff is administered correctly, whether the proper investigation questions were asked up front of like, hey, do you have other reasons you might be exhibiting nystagmus? Do you have balance problems? Do you have a bad hip? A good officer, a well-trained officer is going to administer the tests in accordance with their training. They're going to document it. They're going to make sure the person's capable of passing the test in the first place. But just like at your probably local favorite restaurant, we have an enormous problem with getting officers right now. About everywhere in the country is about 20% understaffed. So they're not getting the best of the best. They're not the best trained in the first place. And they're often entrusted to make, really what are forensically scientifically significant investigations and decisions. I use that because it's sort of a low-hanging fruit example, and that's where sort of the officer on the ground is going to be getting involved in this kind of stuff. But more generally, we are talking about there's some evidence at issue that's been sent to someone who does have a scientific background, to a crime lab of some kind. So, think about your death investigations. Like, did this person just have a stroke, or was it because of the fentanyl I sold them? Anything from DWI to murder to sexual assault, this stuff comes up in. So think accident reconstruction, impairment cases, drug analysis. In North Carolina, you got to prove what the drug is. So somebody's got to look at it and say, yeah, that really is cocaine and not baking soda. Firearms analysis, DNA analysis, blood, other fluids. We sometimes even see stuff like use of force experts. Like, was this a reasonable response that, hey, somebody rang my doorbell and I decided I had to shoot him, right? Sometimes witnesses will be allowed to make opinions like that, or psychological experts are common in the field, right? Because to commit murder or certain other serious crimes, usually we require the person specifically intended that, right? They had a specific intent. And you can make arguments, and we do, that this person wasn't capable of formulating that intent. They're under an intellectual disability, or they were so impaired that they didn't know what they were really doing. These are defenses. They don't work a lot, but they are defenses that exist out there and that get litigated in these cases. So you might also see an eyewitness identification expert. There's a ton of research about the reliability of cross-racial identifications. But this is new and evolving stuff to many of our judges. And I encourage you to go to court, but the judges, again, they're not only not trained, they're also kind of a certain demographic typically that comes from a certain background. And I think that can influence their views on this stuff. There are some sort of procedural fairness things built in to how this is supposed to work. So it's typically the state offering this evidence against the defendant. We often will consult our own experts to try and rebut that, or it might, if it's use of force or eyewitness ID, that might be the defense expert. But when they're coming in with a drug analyst, that's the state's evidence, right? So they're required to tell us, hey, we're going to do this. We're going to bring in a scientist. And actually, the way our rules are written, you can lose the right to question that witness just by failing to object within a certain time period. So they give us notice, we file an objection. That means they've got to come in person. That's good. And then we're supposed to get all the reports and any data they use to back it up. So we can analyze it ourselves, or we can send it to our expert and have it analyzed. But as I think Sarah will help y'all understand or illustrate, again, that sounds really good in theory, and the truth in practice is that they play games with that all the time, so that we get last minute expert disclosures. We'll get a 1-page lab report where no lab report is 1 page. It's typically got 100 pages of bench notes and, checks and and they've decided that this is the only part you really need. And just like with police, we have an underfunded and, in many ways demoralized public defense system. That's not where any lawyer is making money. You can do just about anything else and make better money. There are people that in the public defender system that do this because they care, and those are my heroes, but they're not getting rich doing it. And it does wear on people, and there's a lot of burnout in the field. And I raise all that to say some of the people handling, some of the defense lawyers handling these cases may not know to ask, hey, I should get my own expert, or I need to check with someone about this lab report, or see a one-page lab report and know, hey, that's a problem. I surely have not gotten all the information that I've gotten. And even if they do, there's, like I said, issues of burnout or just laziness or negligence that happens in the system. So it's you know, an interesting and challenging thing. And Sarah's going to go over some of the more egregious examples of sort of misstatement of forensics and overstatement of scientific opinion. Particularly, in my opinion, nefarious practice that we see a lot nowadays is the use of substitute analysts. So this analyst comes in, the analyst does the testing, they write a report, and then someone else comes in and says, I read the report, and in my own opinion, based on this report, I think it's good science. And that's liberally admitted in North Carolina courts. It's kind of questionable as a matter of federal constitutional law. But, from my perspective as a defense lawyer, if I can't question the person who did the testing, what is the value really of that testing? So these are all the kinds of things that we worry about and fight against and rage against all the time. In closing, I just wanted to point out the judge, again, to bring it back, they're the gatekeeper. They have a lot of discretion in whether this stuff gets in or not. And a really savvy judge who's doing his research or his or her research and is on top of these scientific issues, or is willing to educate themselves throughout the pendency of a case when this stuff is going to be coming in. So, I mean, now, not only is DNA complicated enough, we've got cell phone extraction forensics and all kinds of data, expertise now, location data. And, it is possible for, decently intelligent layperson to educate themselves on that, but it takes some effort and time. And if you're not willing to do that, and the practice in many courtrooms is like, well, we've always done it this way. So until somebody says I can't, I'm going to keep doing it that way. And I've never heard of that. So, that can't be reliable. I'm not willing to really seriously consider it. So there's a lot of bias that the players in the system can bring into play with it. And it's a very high standard. If this stuff comes into your criminal trial, or your kid's criminal trial, let's say, it's a very high standard on appeal to get it overturned on that basis. We see cases all the time. We're like, oh yeah, that fingerprint testimony was bad. It was not reliable. It should not have come in. So the judge erred in letting it in. But you know what? In light of everything else going on in the case, it's harmless. We see that all the time from the appellate courts. It's like, this was bad science, but there's other evidence that shows he probably did it. So and you can debate whether you can debate that, but the point is it's an abuse of discretion standard, which in lawyer talk is like a death knell if you're talking about trying to get it reversed on appeal. And harmless error is a doctrine that comes up a lot. I don't want to sound all doom and gloom. There was, as Sarah will mention, the Presidential Commission PCAST that looked at sort of improving forensic standards nationwide. And if those of you that have been longtime North Carolina residents and are reading papers may remember, we had a big old SBI crime lab scandal where stuff like blood splatter evidence was being admitted in crazy ways that had nothing to do with science. In fact, I got asked to this talk, I think, because Chris saw me quoted in this ProPublica story about 911 call analysis. And if you haven't seen that story, I'd encourage you to read it. It's really interesting. But I mean, basically, a cop somewhere came up with a system in his mind out of thin air that said, when somebody reports a child death, depending on the order in which they say things, depending on which words they use, depending on how much emotion they show at which times, I can tell whether they're the killer or not. And as you might imagine, people respond to the trauma of finding a dead child different ways. And it's not easy to categorize that and say, crying here was normal, but crying at this point was not normal. Being hysterical, here was consistent with guilt. And that kind of stuff is, we know of agencies in North Carolina that have been trained on that method. And, to go back to the disclosure piece for a bit, they may or may not tell us that they're using that was used in the case. The officers, and sometimes, and this was what the story was on, the officers will just get up on the stand and say that stuff. And, it can be a thin line, because it is fair for them to say, hey, they told me one thing and I found at the crime scene, it was a whole nother thing. They lied, or they got this wrong. But to say, I have a magic method whereby I can tell who's lying and not, is to me a bridge too far. But I digress. In light of PCAST and the PCAST report and the SBI crime lab scandal we had in the state a few years back, it was probably 5-6 years ago. 10 years. Yeah, there you go. It does. Things have improved, and there is a lot of training we give for, everybody gets, the prosecutors, the defense lawyers, the judges, if they want it. And we do have better understandings of a lot of these things, and some of the more egregious junk science, like, hair analysis, has really been kind of discounted and is not so easy to come in. But we have a whole, even with DNA, which is your gold standard, it is reliable if reliably done and reliably reported, but they overstate their findings, or there's cross-contamination issues that are undisclosed, or there's multiple mixtures, which brings the probative value of the stuff way, way down. Yes, ma'am.
In what regard are the hair follicle tests? Are you talking about drugs, or are you talking about?
Drug testing hair is really reliable, but comparing hair to say, we used to, that's pretty bad, right? We don't do hair anymore. We're still doing it. I'll let Sarah speak to the details on that. I know that it used to be like, they'd say this hair is consistent with a Black person, for instance, and therefore it's consistent with the suspect. And that is not reliable as I understand it, but I'll let her handle the details. To wrap it up, my part of this, I would just say, in light of all those problems, this stuff does result in wrongful convictions at times, and otherwise unjust results that people, the public, or if it's you or your family member, you look at it and say, I'm not sure I feel great about that outcome, whether or not the person was guilty. Was the process really fair? So with that, those are my remarks. Any questions before Sarah in the back?
Yeah. Please wait.
So I got stopped one time and went through the various tests, and I passed. But one of the things you didn't mention is the blow test. How reliable is that?
Well, so there's the portable breath test, the little handheld device that they blow into. And it's funny, that gives them a number, like predicts that you have a blood alcohol concentration of 0.8 would be the magic number. But that number is not admissible, because that's not considered a reliable test. The officer is supposed to ignore the number in their head and only consider that for whether it's positive or negative for the presence of alcohol. How do you think that works on the ground? I don't know how reliable those things are. I've tried them a couple times. It seems to detect the presence of alcohol, if you blow hard. But I don't know. I don't actually know the stats on that off the top of my head. That's another thing where it's like, that's coming in without, there's about nothing we can do to keep that out most of the time. Now, when you get arrested on the roadside and taken into the Batmobile or into the detention center, they'll make you blow again. And that's on a machine called the ECIR2. That's the real test. If they really want it, the gold standard would be blood. And, if people refuse to blow, often they'll go get a search warrant for your blood and take you to the hospital. That machine also is not perfect. It was created by somebody who was the lowest bidder. If the Challenger, if SpaceX rockets can blow up, the ECIR machine can, have error. Yeah, so, and that's, yeah, that's true too. And that I think matters a couple different ways because, you know, one, there's a question of, is me at a 0.08 the same as you as a 0.08? You know, I might have a really high tolerance, or I might, you know, if you're alcoholic, it doesn't affect you like someone who never drinks. But we have a per se limit. You know, it doesn't matter whether you're 500 pounds or 100 pounds. If you blow a 0.08, you're considered impaired in North Carolina. And that's how it is everywhere. Many states are starting to have that now for cannabis. So stuff like drugs are where it really gets interesting because there is no per se limit in North Carolina to how much weed can you smoke until you're impaired, or how many oxycodone, or how many Valium. Right. And I could talk about that all day, but I want to let Sarah.
Can I ask a quick question? Wanted to ask about transparency of the vendors who create the BAT machines themselves. Is that they've been playing, to my knowledge, they've been playing very close to the vest and saying that it's a corporate secret about the software and firmware that's on the machines.
That's the other thing where that comes up and they're claiming trade secrets. There's something else.
So you can't even challenge the veracity of the machine itself.
Yeah, I feel that's reminding me of some other similar result. But yeah, exactly. It's Stingray technology. That's what it is. Which is not exactly forensics, but if you're interested, Stingrays emulate a cell phone tower, and every cell phone in the area connects to the Stingray machine instead of the actual cell tower. And police then can rifle through your phone and record what you're doing, where these phones are, what's coming across the lines. And people have tried to challenge, and then they don't tell you that they used that. They just say investigative methods led us to the suspect. And when we do discover it, we scream bloody murder and say, I want all the Stingray data. I want to know how you did this. I want to know, was it reliable? And they say trade secrets. They'd rather dismiss the case than disclose that to us. ECR2 machines have been around forever, for a long time. And I think they're widely considered, like, you know, have some proven reliability. It's not 100% though, and things can throw it up, like diabetic conditions can throw it off, mouth alcohol can throw it off. There's a lot. I'm not an expert really on DWI. I work more on serious felony stuff, but yeah, I would imagine the same is true. Your chances of getting their software code are slim to none. And if anybody has it, let us know. Any other questions before I turn it over to Sarah? Yes,
I want to go back to the 702 rule
Yes, ma'am.
about experts. Is there any clarification on exactly what an expert is?
No, they sort of are the rules of evidence, and they do this everywhere. It just basically says, well, a proper lay opinion, an opinion from a lay witness, is based on their own personal observations and knowledge that, you know, is helpful for the jury to hear, but doesn't require any specialized scientific, technical expertise or knowledge to, you know, if I say I saw the blue car hit the man in the parking lot, that's fine. I could probably, I'm even under North Carolina rules, I could probably say he seemed to be going fast, maybe 25 miles an hour would be my estimate. I could probably do that. I think our case law says you could visually estimate speed that way. But if I was to say, you know, I don't know, if it's these more technical things like, I believe he had a 0.08 DAC, or, you know, this is evidence of sexual assault, or this looks like accidental death versus poisoning. That's the kind of thing where it's going to be an expert. But no, it's very loose. I mean, one thing I didn't mention is retrograde extrapolation. They'll take you, somebody who's accused of drunk driving 5, 6, 7, 8 hours after the fact, take their blood test then, and then work backwards to say, 8 hours ago, their blood probably was over the legal limit, according to my magic calculations. And there's a way to do that correctly, but there's also a lot of assumptions that go into it. So it's very loose and fast. I mean, a lot is considered expert if it requires specialized scientific knowledge effectively. But some of this is passed off as lay opinion. I mean, that's one of the problems. They pass off expert opinion as a lay, from a lay witness without going through all this rules and disclosure and notice. And if you don't have a qualified, competent defense lawyer, then it just goes unchallenged. That's it.
Okay, so as a defense lawyer, you would challenge it.
Oh,
You
yeah.
would challenge their credentials.
Well, I mean, it all depends. I mean, if I believe the expert is qualified, I may not be challenging their credentials. I may be challenging their opinion or how they apply the methods to the facts of the case, or I may be challenging their ultimate conclusion. Like, yeah, okay, this is present, but I don't think it means what you say it means, or it doesn't go as far as you say it goes. But blood splatter, or the retrograde extrapolation guy, or I can't really challenge the HGN stuff because it's written into the law that it comes in if they've done the class, but we used to challenge that too. And so if it's an officer who's purporting to be an expert, a canine handler, or something like that, yeah, I might call them out on that. It's like, so you took a 4-hour class and that's the extent of your training. You haven't been back in 3 years. You on camera, you're not doing the test right. Like, judge, this shouldn't come in, or you shouldn't give it any weight if it is going to come in. But it's incumbent on the defense. And so that's why we have jobs, basically, is to try and keep the defense lawyers ready for this stuff to ensure that at least the process is fair. So I'm not saying all these people are totally innocent. They're not. But they're entitled to a fair defense under the Constitution. And that's what we work to ensure.
I have some questions, but I can hold up depending on what Sarah is going to talk about.
I'll help as needed.
How long do y'all go usually? Okay.
Well,
I do have to leave by 3 to pick.
Oh,
the
yeah,
bus
that's
up.
fine.
Okay, all right. Well, I would start, I'm going to go over a few North Carolina examples of how forensic evidence has been misused. And I wanted to start with an exercise for you all to give you a chance to try to read a lab report, see if you do a better or worse job than North Carolina attorneys do. So if you have this lab report and it said item number 16 gave chemical indications for the presence of blood, item number 17 failed to reveal the presence of blood. Which item do y'all think has blood on it? 16, right. So that's not right, actually, but that's what the attorneys thought in this particular case. This is actually an infamous case from North Carolina. Who's heard of the Greg Taylor case? So Mr. Taylor was exonerated back in 2010. It's a Wake County case. He served 17 years in prison for a murder that he had absolutely nothing to do with. And the only physical evidence in his case was that the state said that there was a single drop of blood on his truck. And his truck was found near the scene of the crime. And so that language that you saw, this is directly from Mr. Taylor's lab report. And that's what y'all have been looking at. Here's his lab report. Here's where they tested where they tested his truck, the fender liner. And then down here, it says that item number 16, that spot on his truck, gave chemical indications for the presence of blood. And so when his attorneys read that, they thought there's blood on his truck. And that's what the prosecutor thought. That's what the defense attorneys thought. That's what the judge thought. And that's what the jurors thought. And Mr. Taylor was convicted. And what nobody knew was that item number 16 actually did not have blood on it. That was finally uncovered on Mr. Taylor's last bite at the apple. He'd gone through his trial, his appeal, his post-conviction proceedings, and he was finally going before the North Carolina Innocence Inquiry Commission. And at that point, his attorneys got these handwritten notes. These are the notes that the scientist was taking as he was testing that spot that was on Mr. Taylor's truck. And the important thing is the part that's circled that says Takayama, and then it has a negative sign after it. So when his attorneys finally got these handwritten notes that nobody had ever seen, like none of the attorneys previously, the judge didn't see it, the jury didn't see it. Finally, before the Innocence Inquiry Commission, his attorneys get these notes. And my guess is they probably looked up to see like what Takayama is, because, we're lawyers. We don't have science degrees. And so they probably looked up what Takayama was. And what they discovered was that it's actually a more reliable test for blood. And the result of that, according to these notes, was negative. So in Mr. Taylor's case, they've done, and this is very typical of blood testing. They did two different tests. Often with forensic evidence, they'll do a screening test. And that's the spheno and then the positive. And so that it reacted positively on that test. And so that's what the analyst chose to put in his report. He went on and did more reliable tests, the Takayama test, and got a negative result, but did not report it. And so nobody knew about it. And Mr. Taylor spent 17 years in prison. And the reason why they have, you may be wondering, like, why do they have 2 layers of testing? It's because the screening tests, they're cheap, they're fast, they can test a lot of different pieces of evidence and figure out quickly, like, which ones do we need to put some more time into. The problem with the screening tests is they are overly sensitive and they'll react to things besides blood. So we know that they react to things like certain vegetable matter, like I think horseradish and tomatoes. They'll react to like animal blood, other things with iron in it. So it could have been like, I mean, I don't know what it was on Mr. Taylor's truck, but it could have been like a mosquito that was squashed or a bug squashed on his truck. That gave the positive reaction. And that's why they have to go on and do this more reliable test. That's going to take longer. It's going to be more expensive, but you're going to get a more reliable result. The important thing is that you have to report it. So as y'all can imagine, this was a huge problem. And so the response was that the Roy Cooper, who was then the Attorney General, he ordered an audit of the blood testing section of the crime lab. And what that audit uncovered was that there were 230 other cases where the same thing had happened, that there was the negative test that wasn't reported in the final lab report. They also found that there were serious issues in the lab, obviously, that there was poorly crafted policy, lack of objectivity on the part of the analysts, too much discretion left to the individual analysts, lack of transparency, and ineffective management at the lab. And so I was actually wrong. It wasn't 10 years ago, it's about 13 years ago. So like back during that time, it seemed like every few days there was a new headline about problems at the SBI lab. And not just in the blood section, but in other sections of the lab as well. And so as a result, there were, some people lost their jobs. Eventually, the individual who tested the evidence in Greg Taylor's case lost his job, but not because of this case. It was because of he misrepresented his credentials. You're asking about questioning people on their credentials and their training. He had lied about his credentials in the Michael Peterson case from Durham that y'all might be familiar with. So he ended up losing his job over that case. And then also the legislature responded and in 2011 passed the Forensic Sciences Act, which changed the name of the lab. So it's no longer the SBI lab. It's now the North Carolina State Crime Laboratory. And this was an effort to move it out from underneath law enforcement. They changed the statute and said, instead of serving, the lab no longer serves the prosecuting officers of the state, it serves the public and the criminal justice system. So trying to make it more neutral, more transparent, more open to everybody. Yet still, like if I ask them to test something, they won't test it. Like I would have to have a court order if I wanted something from a case tested, but DAs and law enforcement officers just fill out a form and get things tested. And a few other changes. They required that all lab data and bench notes have to be provided to the defense. So now if there were those handwritten notes, we would get them from the state crime lab. And actually the pressing would more come from us pressing the DA's office. Like the state crime lab, they have made a lot of improvements in these past 13 years. And they now do produce like a pretty meaty lab report in every case that they work. The problem is they send it automatically to the DA's office, and then we have to ask for it from the DA's office. And in some cases, the DAs might not understand exactly what they've gotten. It could be like hundreds of pages long. And so, for whatever reason, they may not turn it over to the defense, either, error or, trying to hide the ball. And so we don't always get everything that the lab produces. So it is still a bit of a fight. Phil mentioned the PCAST report, which came out in 2016. And prior to that, our National Academy of Sciences had published a report in 2009 saying that many forensic methods, but in fact, all forensic methods, except for nuclear DNA analysis, don't have enough scientific support to consistently and with a high degree of certainty demonstrate a connection between an item of evidence and a specific individual or source. So it's pretty damning conclusion that our National Academy of Sciences reached. So it wasn't just North Carolina that was having problems related to reliability of science. And then 5 years after that report in 2016, the President's Council of Advisors on Science and Technology looked to see kind of as a follow-up, like, you know, in 2009, we said there wasn't enough science backing up these methods. Have y'all gone through and done the science? And what they found was only in 2 fields was there sufficient science backing up these, you know, supposedly scientific methods. And the reason why, like most of these methods, so these are the ones that didn't have enough, you know, scientific underpinnings, and DNA and fingerprint comparison were the ones that they said had enough scientific support. And the reason why, like, so many of these methods don't have the underlying science is because they really aren't sciences. Like, they are law enforcement techniques. They were created to solve crime. They weren't created in a laboratory, most of them, you know, with the exception of things like DNA or drug testing. Most of the other ones, like footprint comparison or fingerprint comparison, they were invented to solve crimes. And often there hasn't been like the scientific study to prove that they are as accurate as their practitioners claim. So the PCAST report, what it did was it went through and identified like what are the hallmarks of good science, like what do you need in order to prove that your method has enough science backing it up? And these are the things that it came up with. And I think these are the, you know, kind of the things that we all expect to see when we, you know, are looking to see whether something is good science or not. And like Phil said, you know, it's our rule of evidence 702 that governs whether an expert can testify as to their opinion or not. And so it's incumbent on attorneys to understand like what is good science, and then look to see whether the method that's being used in their case has enough science so that it fulfills the requirements of 702. One of the big issues that we see with scientific evidence is a lack of documentation. Like, you would hope that in a fingerprint case, this is what the documentation would look like. Like, this is the latent print from the item of evidence. This is the standard print, and you can see where the analyst has been, you know, going through and marking all the features on each one and then comparing like which ones match up or not. So ideally, this is what we would be getting from the lab, but in most fingerprint cases, this is what we get from the lab, just saying that, you know, just saying in words that, you know, I compared these 2 prints and I identified that, you know, the one print came from the suspect, basically. And that's all the detail that they give in their reports. And with just these words, like, there's nothing that an attorney can do to understand, like, is this reliable or not? Because we're not getting the documentation that looks like this. I think we also all understand that like science needs to be done blindly. Even in taste testing, we know that that should be done blindly because, you know, having information about a case can unfortunately influence a scientist's work on it. So I wanted to, can y'all see that? Okay. So this is the form that is used to submit evidence to the state crime lab. So law enforcement would go through and fill this out when they want an item of evidence tested. I thought we could look at it to see where potentially biasing information might be coming in that could affect the testing that's done in the lab. Do you all see anything? Let's imagine we have a DWI case where they're submitting like a vial of blood to the state crime lab and they want to see if it has blood or drugs or alcohol in it. Do you see anything? Yeah, so they ask for the race and the sex of the suspect, also of the victim, right? Do they even need to know if there's a victim, right? In a DWI case?
How do they define type of contamination, type of container? And
Okay,
description of evidence.
yeah, down here, so it would depend on the type of evidence, but for like a DWI case, it would probably describe like the type of tube, like what color top it has on it.
That seems inadequate.
So, and then hopefully the tube would have like a case number written on it that could be matched up.
So the material of the tube could have an effect on what you're determining. I mean, what you have, both of you have told me that a lot of this forensics is essentially junk science. I mean, a lot of this evidence, I could not even get it published in the Journal of American Chemical Society, let alone anywhere else. Maybe for Ray County Journal of Chemical Chemistry, but.
So they're starting to do a better job with the tubes in DWI cases because it was uncovered that there was a batch of the tubes that they used that didn't have the like anticoagulant in them. And then how do you identify like which tubes were affected if you're not documenting which ones, like are being used in individual cases? So yeah, it's very, very spotty documentation that's happening.
So is this the same form that you fill out as a defender? You said you had to go to a judge and
Right. So no, like there's not a form that defense attorneys can fill out. If a defense attorney wanted additional testing done at the state crime lab, we would have to go to court and ask a judge to order it. And we'd have to present like, legal basis for them to order that additional testing.
And more commonly, like, I'm not using the more commonly, I wouldn't tell a defender to use the state crime lab, even if I could get a judge to order it. I want the guy with the PhD from Duke, I want someone better than who they have at the SBI. I mean, not to denigrate them, but there are people that are
right.
have more, are more credentialed, basically. A lot of these folks are like masters, and they're working at a state agency. That's not the height of scientists, probably.
That this document is being used as someone who you may have found on the side of the road and you're gathering information about them being intoxicated. It does ask, like, have you ever submitted information to this laboratory previously? And it does ask about a court file. So if you're not sure if this person has actually got a problem, does that kind of present any kind of bias, or is it, maybe?
Yes, I think so. So there's, let's see, where is it on here? Well, like you said, they put the name of the, thank you. So the officer that's submitting it puts their name, which I think could be potentially biasing because the analyst may have worked with that officer before, may have opinions about their work. Also, like the county where it happened, like that could be biasing. Like if that you're working, a high profile case from your own county or maybe your own neighborhood, I think that could be potentially biasing. There's also, let's see, it says on here, type of case, so if it's like a homicide from, Orange County and that a homicide happened in your neighborhood, last week, that could be potentially biasing. It gives the date of incident. So there's a lot of information that the lab analysts could get from just reading this form that they have no reason to know. Like if you're the scientist who's testing a vial of blood to see if there's drugs or alcohol in it, you don't need to know that this is for, a DWI where someone was killed, where it happened, when it happened, the race or sex of the individuals involved. You don't need to know if there's a victim, date of birth of the victim. You don't need to know if it's a child. Any of that could be potentially biasing. Even the suspect's name, like you may have seen that suspect come through before. Maybe you found, blood, drugs or alcohol in their blood before. That could be biasing. And then on the second page of the report, this is where law enforcement gets to write a whole paragraph about what happened. And so like all sorts of biasing information can come in here about the crime, like maybe not as much about a DWI, but in homicide cases, or even DWIs, like statements that people have made, all of that information could be written on the second page of the form. So lots of information that a scientist does not need to know. And there may be cases, like maybe when they're doing DNA testing, they might need to have some information about like how many people were potentially bleeding at the scene. But can y'all think of any way to deal with that at the lab? Let's say they get, a form like this and they need to, the scientist, Phil's the scientist, he needs to do the DNA testing. So what procedure could we use so that Phil doesn't get all the information about, that this is a bloody murder? All he needs to do is test for DNA. Anonymize things, have like a screener in the office, right? So like, I think it's fine for law enforcement to submit this information, and it may be useful for like, in some cases, they may legitimately need the information, and it may be helpful to, match up which evidence belongs to which case. But yeah, they just need to anonymize things or use a screener, but that takes more resources and it's not being done. And so, what we're left with is like lawyers like me trying to figure out, is this good science? And, most of us went to law school because, we were smart, but we didn't want to have anything to do with math or science. If we did, we would have gone to medical school, right? But we went to law school because we did not want to do math or science. And then even, in the practice of criminal law, almost every case, that we come across involves some sort of expert testimony, some sort of forensic evidence. And so we rely on the help of other experts. Like Phil said, if we want additional testing done, we would, look for our own expert. Typically, we wouldn't go to the state crime lab and ask them to do more testing. There may be some cases where we would do that, or we may order that, we may ask a judge, more like we would ask the judge to order that the state crime lab preserve enough evidence so that we could have it independently tested. This is my website, and attorneys can go here to find experts to help them in their cases. So I have a database of experts on my website, and we have several hundred in there, but we don't have enough. And so, our experts are invaluable to help educate us on whether this is good science or not. So if any of y'all are scientists, if you're retired or have any time that you would like to contribute to this effort, I would like to be in touch with you. I think that members of the community could really help us to understand a lot more about whether this is reliable evidence or not. So I'll pass around my cards so that y'all can have them. And then I put our contact information up as well, and then happy to take questions from you all.
Thank you, both of you, for the wonderful.
I did just want to mention, because we didn't put it up there, I'm one of the authors on the North Carolina criminal law blog. And that's a really good resource, just to find out stuff about the law. And, we do like a news roundup every week. So I'm not plugging myself, but if you're interested in this stuff and want to follow it, the North Carolina criminal law blog by the School of Government is a really good place to bookmark and check it once a week or whatever. I write a lot about cannabis issues in the state, which is a huge evolving thing if you're interested in that. But it could be all kinds of great information is on there insofar as it relates to criminal law. And Sarah's website, forensicresources.org, is even better.
I have a blog.
With forensics. Yeah.
You can subscribe to the blog if you're interested in scientific issues. And whenever I see an issue that a lot of attorneys are dealing with, I try to put together information that's going to be helpful for them to alert them to the issue, and then they find the resources that they need.
What do you do when it comes to the softer sciences, the psychological evaluations, forensic psych evaluation, whether or not somebody was competent to defend themselves or was, knew right from wrong at the time of the crime and that kind of stuff? Because one is, we've been talking about physical evidence, but then when you got psychological evaluations from the experts out, well, not Dixon anymore, Butner, what do you do to, I'm not going to say discredit or to balance out or to challenge those findings.
I always encourage attorneys to get their own experts when there's been a state expert evaluating their client. We have them in our database of experts as well. And then, you can have an independent expert reevaluate your client, and there may be additional information that they're able to take into account that you can provide to them. So yeah, we definitely utilize psychologists, psychiatrists, and other mental health experts.
And what you end up with is a battle of the experts, right? One testifies, the other testifies, assuming everybody can get it in. And then it's for the jury or the finder of fact, the judge or the jury to say, I believe this one more. Yeah, I believe he didn't have the requisite state of mind, or you know what, I think he did. Or he's, if they're found incapable of proceeding, this is happening all the time right now. We can't evaluate them quick enough. There's not enough beds. So these people's cases sit in limbo, but when we finally do get to court on a competency hearing, the state's person might say that they can stand trial. Our guy says they can't, and the judge has to decide that issue, make findings, have a hearing, and believe one or the other. So that's what happens. It is up who do you believe? And it's a layperson effectively making that judgment call.
Yeah. I remember when the elemental analysis thing for bullets came out in the papers. And so apparently it's not as reliable. And I can see that. Are rifle marks as precise for identifying guns as it is supposed to be? And just.
No, it's not.
And one more thing, if you watch Perry Mason, he knocks down fingerprints and all this stuff. So he knows it all. It's impressive.
So firearms evidence is an area that attorneys are regularly challenging in North Carolina. And the examiners who do those comparisons, they often overstate the results of their comparison and say, like, I'm 100% certain, or there's, 100%, I have a 0 error rate, or this bullet had to have come from this firearm to the exclusion of every other firearm in the world, and use language that is not scientifically supportable. So yes, firearms comparison is one of the areas that I'm often helping attorneys challenge, but it regularly is admitted in court. And it like Phil said, it's very difficult to overturn on appeal. Like if the analyst says, like, they might not put in their report this, extra language, like I'm 100% certain and I've worked, 1,000 cases and I've never been wrong. They don't put that in their report, but then when they get up on the stand, you're laughing, but like literally that's what they say. And like, how do they know that they've never been wrong? Like they're basing it on casework where like, they don't know the ground truth. They don't know if they were actually right or wrong in any of the cases that they've worked.
And didn't you work on a case recently where there was some testimony like that from the analyst that said, I've never been wrong in my life, and she had just been disciplined for just been disciplined for her scientific errors. That's the level of dishonesty that sometimes we encounter in these cases.
I have been reading where the legislature wishes to change the accountability of the lab from one area of government to another. Is there any reason for concern about the oversight that might change?
No, this current session is there.
Are you asking if we have concerns about lab administration or whether we have opinions on the legislation?
Mike asked my questions.
Yeah, I don't know.
Yeah, no, if they're seriously considering moving it right now, but they did move it back in 2011. It was part of the State Bureau of Investigation, like our state police. And then they moved it to be under the Attorney General's office, which is like the head prosecutor of our state. So it's an improvement to take it out from underneath law enforcement, but it's still in like the prosecution's arm of or branch of government. So, ideally it would be completely independent. And, not under the supervision of the prosecutors or the defenders or the police. It would be completely independent. So that's what I would like to see. But there's, very few labs that are actually forensic labs that are actually independent. And surprisingly, in Texas is where one of the most innovative and independent forensic labs is. It's in Houston, and it's completely independent from law enforcement. So hopefully we'll move that direction today.
And I think as Sarah alluded, like the lab is much more transparent than it used to be. It used to be they wouldn't even talk to us, and now they'll talk to us. If the defense lawyer calls and says, "I want to ask you some questions, analysts," ahead of time, they'll talk to us and return our calls now. So it's a huge improvement. I believe they have a very capable and well-intentioned director right now and good administration.
We actually came from that lab in Texas to Houston.
Huh, I didn't know that, but are there still issues on the ground? Absolutely.
I'm a little confused about fingerprints. The slide showed that fingerprints were admissible, but I thought that you were saying that they were not good science. And also I've heard a lot about that there are duplicate fingerprints out there. So
I mean, we don't know the ground truth. We don't know that like fingerprints are unique. Nobody's actually done that science. So it's possible that there are very similar. There's famous like fingerprint mismatch cases, like the Brandon Mayfield case. He was an attorney in Oregon who was charged with the Madrid train bombing many years ago. And they said that they said they found his fingerprint on like a bag of detonators. And then another country did a rework of the evidence and found that it actually matched, somebody with like terrorist ties who had been to Spain. Like Brandon Mayfield had never been to Spain. So there are errors in fingerprints. They have fingerprints as the one field that has been, maybe not the one field, but it's one of the fields that's further along in doing the science to study how accurate it is. And so I think that's why the PCAST said that there is sufficient scientific underpinnings, but it has to be done following, the correct procedures. And in many cases, the fingerprints, if they're done at the state crime lab, they probably are, following most of the best practices. But with fingerprints, they're often done by law enforcement out in the field, by like a local police department. And they are not following the best practices. They're not providing this type of documentation. They're the ones who are providing this report that gives you no information about how they came to that decision. So in some cases, it probably is reliable. But in many of the cases that we actually see, there do need to be 702 challenges to the admissibility of that evidence.
Do you, either of you remember the famous case where the FBI lab was fabricating data in the 90s?
It's funny you asked.
For many years, because I was in a conference with the replacement director came to speak. And I felt sorry for her because she was so abused by the audience.
I think it's the same situation you're talking about, but Sarah and Olson and I both are friends and colleagues with an attorney and former FBI chemist in Bethel, North Carolina, named Fred Whitehurst. Y'all look up his Wikipedia page. This guy's had an amazing life. I mean, he helped. He was the lead forensic investigator for the Oklahoma City bombings in the 90s and blew the whistle on the shoddy practices of the FBI crime lab, for which he got fired. And then he won a whistleblower lawsuit and then went to law school. And
they were actually conferring with the prosecutor to find out what sort of evidence he required and then providing the right evidence.
Yeah, there was all kinds of the same kind of problems that Sarah just whatever with our FBI crime lab. The FBI was having those problems 10, 15 years.
We had a three, maybe you want to just have
And
a
I do
question?
need to scoot after this last question.
So the last two questions, and then I'm going to come to you.
Thank you, Amy. So my question is kind of just getting your insights on the future of maybe how courts are run. I can compare it to healthcare, how people had to go back and get business degrees because we were healthcare workers, but not business people. Do you all see that happening in law where people are kind of cross-training themselves and kind of inserting themselves like yourselves in the courtroom or advocating in the courtroom?
So I think law schools are doing a better job on educating about scientific evidence, but there's still a lot of room for improvement. Like when I was in law school, I didn't take I don't know if I ever heard the word DNA. Like I went to Berkeley and like I wasn't interested in intellectual property. So like I didn't do any of the science and law classes and got my law degree. It's not on the bar exam. I wish that there were more requirements for training in law school. But Phil and I do a lot of work trying to train the attorneys who are in court doing this work. I have a monthly webinar that I offer for attorneys on scientific evidence, and Phil puts on the Public Defender Conference every year, and there's always a lot of sessions on scientific evidence there. So we are trying to catch up, but still there's not enough education on the science.
Hi, my question goes back to the DWI case where you use a side of the road breathalyzer, and then there's a more accurate machine. Now, those machines need to be maintained and calibrated. And do you get records when you have a report that about how frequently that machine is calibrated and when it was done last?
Yes and no. There's both a sort of a certification requirement that the person doing the testing, at least the one that counts, they have to be certified. And so it'll usually say certification is good until this date or whatever. If you want to see the maintenance log records for the machine, those are online, and it's like a 1,200 page document, and you just start scrolling until you find Pitt County Detention Center, Orange County Detention Center, machine 1, or whatever it is. It's almost intentionally hard to find.
And not all of the information that attorneys want is in those records. Like I was at a training for attorneys this week, and they're going to get like the standard deviation and for the accuracy of the machines, and they couldn't get it. Like they're trying to get it from PHHS and just couldn't get the information from you. So
It's
not as transparent.
it's past 3, since we have to be out by 3:30. Yeah, I'm going to call the end to the questioning. So thank you again.
Yeah, thanks for having us.
Thank you.
So we want to have our closing words and announcements. What's next week's program? Mara?
One announcement, very important. Do not come here next week. We will not be here. And in fact, do not try to log into the EHST Zoom thing, because next week is an all AEU platform. And it'll be at 11 in the morning. And I'm going to hand Chris the microphone about that. I also want to mention really quick, because we have different people who are doing the cleaning than used to, we're sort of rearranging our time. And this is just a reminder. We aren't guaranteed that the doors are open until 1:30. Sometimes the cleaners are done earlier, often they're not, which is why we're saying to everybody, hey, doors are open at 1:30, program starts at 1:45, because otherwise people like Chris dealing with the Zoom cannot possibly get it done in 2.5 minutes. Just a quick reminder, and I'm going to hand over the mic to Chris.
First, I wanted to say that our excellent program today was brought to you by Mark Hutchinson, who let me know. So thank you, Mark, and keep the good suggestions coming.
Always be recruiting.
And the program next week, that's the all AAU program, is called Our Climate Future with Our Children's Trust. So that's going to focus on the youth versus government case in Montana. So I hope you can make it for that, and be sure to look for the email that will have the link to the program that starts at 11 o'clock Eastern time. I don't know if you have to register ahead of time. Look closely at your email.
Amy? Oh.
Jennifer
Jennifer has.
Yeah, I have an announcement. So tomorrow evening from 6 to 8, there's an event called Poetry on Your Plate, which is going to be in Carborough. And it's basically, if you want to bring something, for dinner, you can do that, but they're going to have environmental poetry. So poetry about the environment, and they'll have snacks and all that there.
Where?
It's at the 100 North Greensboro Street in Carborough. So I guess that's no, I think it's that big building that they have.
Oh,
Yes, I think that's where it is.
Change for change. Sorry. Quick change for change announcement. We are changing over our organization to the Interfaith Council for Social Service. Where's Jan? The IFC. Their vision is a community that meets everyone's basic needs, including dignified and affordable housing, an abundance of healthy food, and meaningful social connection. The mission is to confront the causes and respond to the effects of poverty in our community. So it's our organization that we will support for the next quarter. So please donate.
Yeah, I don't need this. I've got a number of extra copies of my magazine, the current one for Final Exit Network, extra ones over there on the table. So help yourselves if you want to take one home.
Okay, my closing words are another poem by Jack Tomkovic. And since we're fully into spring now, and the hummingbirds are back, this is a poem called In Midair. Hummers hanging in midair like iridescent green-gray miniskirts drying on the line, sun glinting off ruby throats like a Klimt painting, shimmering prisms of color dancing on heated air, two-steps and tangos, sambas, and swing. If they came in gold, sunglasses shade and cool, nectar like lemonade, all the rage, with diamond sparkle, dips, helicopters hovering, discovering fight or flight at racing speed, puzzling and playing, hummers hang in midair, petite lions and tigers squeaking their fury while they cling to tiniest limbs like prima ballerinas holding the plie pose.
Thank you, Amy, and thank you, Jennifer, for greeting. And thank you, Chris, for doing Zoom. And John and Jean did the spread today, which looks lovely. And I think that's, and thanks, Mark, for bringing that great duo to speak on forensics. And thank you, Mike, for putting out the sign so faithfully every week. It's very important. And so our program's done, but our fellowship begins. So we have 20 minutes before we have to be out of here. Eat